Hello everyone, I'm so excited for today's class. You must be having last minute anxiety like all the students. So, this is not something new to you. You must be having issues like, have I read enough? Am I really going to know everything that is needed? You must be thinking about so much. I'm here to help you in order to understand how to beat these last minute blues. If you're new to this channel, make sure you're a subscriber to it. So if any important video comes of such significance, you are updated. Also ensure that you press that bell icon. All right. So we are going to talk about the most important Supreme Court judgments for the year 2023, which are going to be excessively helpful for your UPSC 2024 examination. First of all, you must know that I provide all the PDFs that I use here on my Telegram channel. This goes by the name of Pooja Dwivedi UPSC. If you have any queries, you can talk to me on my Instagram. If you have any suggestions, please do not hesitate. Now, if you want to follow me, you can do it on my threads as well. Who uses threads, by the way? Let's talk about Justice Clock. Before I begin with so many important events, let's talk about Justice Clock. We are going to keep our minds in judiciary today. Justice Clock is actually an initiative that has been undertaken with the help of Department of Justice. And this Justice Clock is working across at least 25 high courts. In these 25 high courts, we see an LED display which shows us the different data regarding pendency of cases and other important data that is taken from the National Judiciary Data Grid. The National Judiciary Data Grid has all the information about which cases are pending where, how much time does it take, at the district level, how much time does it take. Everything is told through this beautiful LED display panel so that people have the right to know how our judiciary is doing. Another one is Suswagatam portal. This actually helps the visitors to have a very smooth functioning and functioning of when it comes to getting online e-passes so that they do not have to wait in queues. And access to justice is one of our basic principles. Then we have the e-seva kendras. This is actually a brainchild of our own Chief Justice of India. And the Chief Justice of India thinks that if anybody wants to get any sort of seva or any sort of help regarding the inquiry about how many cases have been done away with, what is the situation of a particular case, that can be taken care of by the e-seva kendras. All right, now let's move on to the main thing, that is understanding how our judiciary worked for the year 2023. Our judiciary pronounced 1067 cases, Supreme Court specifically I'm talking about here. 1067 cases, important judgments were given, which is a little lower actually if we compare it by the year 2022. Back then it was 1263. For the year 2021, it is of course 865, and for the year 2020, which was of course a COVID era, it was 696 only. So we are going a tad bit lower than 2022. Let's move on. Many important and landmark judgments were given this year in 2023. So we will first talk about upholding demonetization. If we talk about demonetization, you must be thinking that took place in the year 2016, right? Now, what is the purpose of pronouncing a judgment today? Because it helps the executive to understand where did it go wrong, where it didn't go wrong, where it did correctly. This particular case is known by the name of Vivek Narayan Sharma versus Union of India. And here, a majority of 4 judges on a constitution bench was formulated. If ever a constitution bench has been formulated, it is in order to interpret the constitution. You have to keep this in mind. Interpret the Constitution of India. So a constitution bench has been formulated. It found out that no flaw is there in government's process to demonetize 500 and 1000 rupee standard bank notes, which the government did through a gazette notification. And this gazette notification was issued on November 8th, 2016. Through this gazette notification, 500 rupee notes and 1000 rupee notes were no more a legal tender. No more a legal tender means it was not at all qualified to be exchanged whenever we are going to buy something. And that is why it was needed by the people of India to exchange these notes, to submit these notes to the RBI. So, demonetization is something that has not been done for the very first time ever in India. It before 2016's demonetization, already twice India went through demonetization. The word demonetize was first used by the French between years 1880 and 1885. What does it mean? It means that demonetization is a process by which a nation's economic unit, our economic unit is rupee, economic unit of exchange, it loses its legally enforceable validity. That means people, if they refuse to accept it as a legal tender, they could do so. The first ever demonetization in British India was carried out in the year 1946 on January 12th. The second one, post independence, took place in the year 1978, and this was done on the recommendation of the Vanchu Committee. So you have to remember that as well. Let's talk about the demonetization of 2016, which happened on November 8th. According to the Section 26, Clause 2 of the RBI Act, the Demonetization Act, the demonetization of standard banknotes of 500 rupee and 1000 rupee took place. All right, so you have to remember this because this section, a question related to this section can be asked. The standard banknotes, SBN means standard banknotes. These were notes of the denomination rupees 500 and 1000. And promulgation of or an ordinance took place on December 30th, 2016, which was done by the President of India. Now the question was this at all legal and constitutional or not? So section 26 clause 1 says that every banknote shall be a legal tender as per the amount expressed therein and shall be guaranteed by the central government. But section 26 clause 2 said that banknotes can cease to be a legal tender when the central government issues a notification in the Gazette of India. So it was not at all unconstitutional or against any act. It also specifically said that whenever a government has to issue notification, it can be done on the recommendation of the central board of the bank. The central board of the bank comprises of course, the governor, which is of course Shaktikant Das right now, and not less than, remember, not less than 4 deputy governors. Other than this, we also have non-official, governors here as well. The 10 governors, the 10 directors who are nominated by the government of India, and they also include 2 government official. It also includes 4 representatives from the local boards. So this is the central board, and the central board actually works along with the board on financial board on financial supervision. This particular board helps the central board of the bank, the RBI, to work properly. Let's move on. Let's talk about the key points of the verdict. First of all, the Supreme Court said that the notification which was issued by the central government of India in 2016 is not at all flawed, and it is done as according to the section 26 clause 2 of the RBI Act. So here I told you what section 26 clause 2 was. Other thing is that the central government is completely empowered under this section to notify any series of banknotes of any denomination to cease to be a legal tender. So the Supreme Court upheld the demonetization move. It also said that power available to the central government under section 26 clause 2 of the RBI Act cannot be restricted to mean that it can be exercised only for one or some series, because it can be exercised for all series. So this is what the Supreme Court said. Now let's talk about another very important judgment. New guidelines were given for passive euthanasia. Euthanasia is also known as mercy death or mercy killing. So here, as we see, we are talking about passive euthanasia. We are not talking about active euthanasia. Active euthanasia doesn't find any ground in the Indian legal system right now. And this particular judgment came in the common cause, which is a registered society versus the Union of India. Here, the Supreme Court in India has made certain changes for passive euthanasia to make the process less difficult and less time consuming. If anybody wants to go through passive euthanasia, this can be done for people who do not have any chance of reviving their body back to the health that it was, and their death is imminent, but the process of dying is really painful, and it could be seen that making that person die, or if that person dies, is better than living. So this is what euthanasia's rationale is. Passive euthanasia is different from active euthanasia. In passive euthanasia, we completely prohibit giving certain things which are supporting that person's life. In active euthanasia, we involve ourselves in active killing of that person. This is the difference between passive euthanasia. For example, if anybody comes in a vegetative state, vegetative means cannot move, cannot talk, cannot breathe properly, and they're just lying on the bed and their life is becoming hell like that, we can remove their oxygen supply system. We can, of course, put them away from the ventilator system. This is kind of passive euthanasia because we have withdrawn certain life supporting things. In active euthanasia, we may inject any poison into that person's body that will make them die. So this is the difference between passive euthanasia and active euthanasia. The passive euthanasia is better known as the act of withholding or withdrawing medical treatment, withholding or withdrawing life support by an intention that the person may eventually die. So euthanasia in India was actually legalized on a passive basis back in 2018, and this became a part of the living will. So if any person wanted to ensure that someday they want to die because their body may not be able to sustain themselves, they can write it in their living will. An adult, whoever is in their conscious mind, not any drugged mind, but conscious mind, they know what is happening around them, they are permitted to refuse any medical treatment or voluntarily decide not to take medical treatment, to embrace death in natural way under certain conditions. So what the changes have been done? Living will, if any person has to develop this sort of passive euthanasia clause in the living will, an attestation by a notary or a gazetted officer is sufficient for the living will, because the right to die is also actually a part of Article 21, which is right to life and liberty. If I choose to die and I do not have any better prospects to go for, if I want to live, I know that it will be very painful for me and my family, then I can have the right to die with dignity as well. This is also a part of Article 21. And access to the living will is actually a part of, it will become a part of national health record, so that Indian hospitals can access it. However, it is in contravention to what? Article 21, specifically here again, right to privacy. So right to privacy, but the rationale here is to make sure that others also know what kind of passive euthanasia can be done and in what cases. So right to privacy, there is a contravention, but eventually for the collective good, this can be overlooked. Primary board, who is going to examine the patient's condition, if it is okay for them to go through passive euthanasia or not, there will be 3 doctors, which will include the 2 treating physicians, those physicians who are treating the patient, and 2 other doctors with 5 years of experience in specialty. They will comprise of the primary board of doctors. The time taken to decide will be within 48 hours when we talk about the primary or the secondary board. And secondary board, hospital must immediately constitute a secondary board of medical experts if the primary board has decided, so that we treat a patient not like somebody we need to get rid of, but we should ensure that they are taking the right decision. Next, very important, very extremely important judgment was the appointment of election commissioners by 3-member committee of Prime Minister of India, leader of the opposition and Chief Justice. This is what the Supreme Court has said. The Supreme Court decided so in the Anup Baranwal versus Union of India case of 2023. That happened through a 5-judge bench. It ruled on the matter, examining Article 324. Article 324 talks about the Election Commission. Now, our forefathers, when they developed the constitution, free and fair elections were one of the basic structure articles. Like Article 324 says that the election commission should superintend, control and direct the elections. The election commission deals with the elections of the parliament. First, that we can write it so. How many kinds of elections are done? Of course, with the help of the parliament, with the help of the election commission, we get the parliament elections, the state legislative assemblies, the office of president and the office of vice president. So these elections are conducted by the election commission according to article 324. However, here there was a problem that executive is trying to intervene in the matter, and if the executive is trying to intervene in the matter, if the prime minister or any other minister who is already in power is intervening in this matter, that is of course not in the favor of fair election process. So the Supreme Court said that we can have a particular committee that will comprise of the PM, the leader of the opposition and the CJA. So Chief Justice here, not Chief Justice of India is not written. It is written a Chief Justice, right? So the thing is that right now we do not have this committee. We have a committee that comprises of Prime Minister, leader of the opposition and a union minister who is nominated by the Prime Minister. So, this particular procedure has been established by a bill that was passed after this judgment in the parliament. Now, here also the Supreme Court says that they cannot do much because this is under the ambit of the parliament as according to the constitution. However, this is actually a suggestion. So, when the forefathers talked about keeping the country in better democratic hands, it of course had in mind that executive won't get to say much, but recently we saw that the executive is going to say much. Now, because here the prime minister and a person who is nominated by the prime minister is already in this particular committee, of course it is going to hinder the fair process. Now, was this the first time ever that a consultative process was considered? Consultative means a committee is developed and it is going to select people from a list that is prepared by a department. No, in 1990, a committee chaired by the then law minister Dinesh Goswami also suggested a committee precedent to consult the Chief Justice of India, the leader of the opposition, or the leader of the largest opposition group for appointing the Chief Election Commissioner. This was the recommendation. For the other two election commissioners, the consultation was to involve a Chief Justice of India, the leader of the opposition, and the Chief Election Commissioners. But this is not undertaken right now. What happened after this judgment? The centre got really upset and they introduced a bill in the parliament. Since the court already said that the appointment norms are subject to any laws made by the parliament, that is why this bill is not unconstitutional that was brought. However, the appointment process proposed in the bill was very problematic because, as I told you, it comprises of the prime minister, the leader of the opposition of the Lok Sabha. Remember this as well, because it could be written Rajya Sabha, no, Lok Sabha, and a cabinet minister who is nominated by the PM. So here the heft of course will be of the executive, the people who are in power, and they will select persons from 5 names which are shortlisted by a screening panel, and this screening panel is headed by the law minister, which also comprises of 2 union secretaries. So again, executive. Now, another very important matter that was, of course, a lot talked about in the year 2023. The Supreme Court upholding the abrogation of Article 370. We already saw the movie. It was actually really good in telling us how it all happened. However, it was also being touted as a propaganda movie. You decide whatever it was. I'm not in a mood or not in a place to comment here. Let's talk about this. Now, the Supreme Court rightly so said in a 5-0 unanimous ruling. That means none of the 5 judges ever said anything against the centre abrogating Article 370. They were all of the similar opinion that it was done for good. The 2 presidential orders constituted of the Constitution application to Jammu and Kashmir Order 272 and 273. That happened in August 5 and 6 respectively. And this also divided the state of Jammu and Kashmir into 2 union territories, the union territories of Ladakh and the union territory of Jammu and Kashmir. the Union Territory of Jammu and Kashmir, had to have a state legislature, but the Ladakh one didn't. So this is one thing that we must keep in mind, that it had a state, this one has a state legislature, this one doesn't. That is why Ladakh is really upset, and it wants to get a very special status in the sixth schedule of the Indian Constitution, because it is not being ruled by their own elected representatives. So this is also in the news, that the Home Minister has said that that an Article 371 like arrangement can be arranged for Ladakh. So let's move on and talk about this one, of course. First of all, let's talk about Article 370. Article 370 gave a special status to Jammu and Kashmir as a state. It guaranteed special status in many matters. It allowed the state assembly to have its own constitution, its own flag. It also had separate set of laws for states residents, as such as citizenship, ownership of property, and they had their own fundamental rights. So it was basically a part of the country only in name. However, it was working according to its own wishes. Citizens from other states were not at all allowed to buy or purchase land property in the state. State also couldn't declare financial emergency under Article 360 in this particular state. So this became a real problem. Whenever the Constitution of India had to apply in Jammu and Kashmir, it couldn't. Why? Because of Article 370. It was completely against Article 14, Article 16, Article even 21, Article 25 as well. There were many things that were actually against the special status. But the Supreme Court swooped in and said that there are certain matters which suggest that Jammu and Kashmir was always a part of India, and it was something that it couldn't be questioned. However, many people even questioned, was Jammu Kashmir really a part of India or not? Supreme Court swooped in and said, according to Article 1, Jammu Kashmir was part of the Part 3 as a Part 3 state before 2019. It was in the first schedule of the Indian Constitution. That completely made us understand that accordingly, Jammu Kashmir was, of course, a part of India. Secondly, Section 3 of the Constitution of Jammu and Kashmir itself declared that Jammu and Kashmir is an integral part of India. So, why a special status? The CJI also said that there were two aspects that showed that Article 370 is of temporary nature. Firstly, it was just an interim agreement. That means this agreement was not substantially permanent. It was not to go for a long period of time. It was just an interim or transitional agreement that was made until the Constituent Assembly of the state was formed. There was a need of legal bridge between Jammu and Kashmir and India, because India wanted to conduct a plebiscite over there, but because Pakistan was excessively scared if a plebiscite happens, it was for sure that Jammu and Kashmir will be a part of India. So they terrorized the people through Pashtun tribes. They got hold of the illegally occupied Kashmir. So what happens, that this was also an arrangement that was experiencing warlike conditions, for the areas that were experiencing warlike conditions. So this was not at all permanent in nature. Another thing that the Supreme Court said, that governor can assume all or any roles of the state legislature. This was also put out. The court said that the proclamations that were done in the landmark 1994 ruling, the SR Bommai versus Union of India case, it dealt with the powers and limitations of the governor under precedent's rule. So governor can assume all or any roles of the state legislature once the constitutional machinery is failing. Another very important judgment was there. The Supreme Court said no to same-sex marriage, saying that this is not our domain. This is the domain of the parliament. If the parliament can make any changes or regarding any law or anything else, it is only the parliament's area, not the area of Supreme Court, so that judicial overreach doesn't happen. This all was in the Suprio versus Union of India case 2023. A 5-judge constitution bench of the Supreme Court that was headed by the CGI in a 3:2 verdict. This is the majority verdict and this is the minority verdict. That means 3 were in favor of saying no to same-sex marriage. 2 were in favor of saying yes to same-sex marriage. They said that giving constitutional validity to same sex marriage is not at all something that we want, because it's a domain of the parliament. The court will can and cannot the court cannot strike down or read words into the Special Marriage Act of 1954, because here the basic need of the litigants was to ensure that people of the same sex can marry under the Special Marriage Act of 1954. The Special Marriage Act of 1954 was actually made in order to facilitate marriage between people belonging to different faiths. For example, if a Muslim wants to marry a Hindu, they can do so under the Special Marriage Act without converting their religion. But here, same sex members wouldn't lie in this ambit. The Supreme Court said that the relationship of marriage is not static one. It can change. It can be between people of the same sex as well. Supreme Court says that equal rights and freedom can be given to the people who are queer in nature, who are belonging to the LGBTQ group, so that they can feel belongingness in the society. All the five judges on bench agreed that there is no fundamental right to marry under the Constitution. It is not your right to marry. It is, yes, your right to live your life according to Article 21. But here, the Supreme Court did not read too much into it that they have the right to marry. However, the minority opinion came from Justice Collins, CJI. They said that we can definitely give an extension of civil union to the same sex couples. That means if they want to enjoy any rights that can be guaranteed in any constitution, in any working polity, they can be registered as a civil union. This is just like marriage, but it does not get any acceptance from the society as marriage. This is the only difference. Now, there were certain views of the Supreme Court on same sex marriages earlier as well. For example, marriage as a fundamental right. This was decided in the Shafin Jahan versus Ashokan KM and others. Here, the Supreme Court invoked Article 16 of the Universal Declaration of Human Rights and also the Puttaswamy case. If anybody wants to anybody who belong to the same sex marriage, it need not to be declared, because in the Puttaswamy case, right to privacy was of course talked about. However, if we talk about Article 16 clause 2 of the Indian Constitution, it says that the state will not make any discrimination on the grounds of sex as well. So one cannot make discrimination on the grounds of sex, that if a person is marrying another person of the same sex, they will be discriminated against. Then LGBTQ community entitled to all constitutional rights. This was the Navtej Singh Johar case and others versus Union of India 2018. Here it said that the LGBTQ community, they are entitled as all other citizens to have the full range of constitutional rights, which also includes equal citizenship and equal protection of law. Let's move on and talk about the next very important news. A next very important case actually. Let's talk about the Supreme Court upholding the amendments which were made by Tamil Nadu, Karnataka and Maharashtra to the Prevention of Cruelty to Animals Act 1960. This was the Animal Welfare Board of India versus the Union of India case. Here the Supreme Court has said that whatever amendments that have been made by Tamil Nadu, Karnataka and Maharashtra to the Prevention of Cruelty to Animals 1960, in order to get on with sports such as Jallikattu, Kambala and bullock cart racing, it is allowed. It is not at all against the constitution. If we talk about Jallikattu, it is actually a sport. It is a taming sport, which is, let me just clear my pen properly so that you can read into it. It's a sport. It's a taming sport. It happens on the third day of Mattu Pongal in Tamil Nadu. Mattu Pongal. And if we talk about that is since when it is being conducted, some people say, of course, there is a mention of it in the Tamil classical age. It has been said since the Tamil classical age it is being conducted. All right. So this is something that you must know. It is also known by various other names. What kind of names are given to it? Let's talk about it. Other sort of names for Jallikattu include, as you can read here, Yeru Thazu Wuthal. Yeru Thazu Wuthal. All right. Then we also have Madu Pidithal. Madu Pidithal. Then we also have Polerudhu, Polerudhu, Pidithal. These are the different names for Jallikattu. And this is one of the most important and very popular sports of Tamil Nadu. Now let's talk about the other one, which is the Kambala, and this is the Buffalo Festival. It's a buffalo race. Remember that. Okay. So I'm just going to write here. It's a buffalo race. It happens in Dakshin Kannada. Dakshin Kannada. I hope I am pronouncing it correctly. My Karnataka students, please do tell me if I'm doing it wrong. This is not because of ignorance, of course. This is just because of the learning procedure. Okay. And this is a unique buffalo race that takes place. Let's move on and talk about another very important news that was, another very important case that was so much in the news. The Modi name defamation case. This was in the Rahul Gandhi versus Purnesh Ishwar Bhai Modi. Back in 2019, Mr. Rahul Gandhi made certain allegations about the Modi surname. I'm not going to repeat it, of course. He said certain things which did not sit well with the Modi community. So the particular case went to a court in Surat. And there, the court decided that Rahul Gandhi is guilty in this particular case. So Rahul Gandhi moved to Sessions Court. He sought a stay in the conviction. That did not happen. After that, on August 5th, the Supreme Court took cognizance of it and they stayed Rahul's conviction, saying that according to, if they will go according to Section 8, Clause 3 of the Representations of People's Act of 1951, Mr. Rahul Gandhi is presenting a lot many people as an elected member of the parliament. So if he is convicted, he will be barred for elections for at least 8 years. And this is not going to be serving the democracy. That is why it has been done. Any disqualification of a legislature is prescribed in three situations, according to Article 102, Clause 1 and 191, Clause 1 for the disqualification of a member of the parliament as well as the state legislative assembly. If any person is holding an office of profit, if they are of unsound mind or insolvent, of course, this is all done by a court of competence. If they do not have a valid citizenship, then they can be disqualified according to the 10th schedule of the Indian Constitution. Of course, this is the anti-defection law. They can be disqualified. This is another story. Anti-defection law, if they are joining any party illegally, something like that can happen. Anti-defection law can come into place. This is a more complex matter. We need another video for this. The third prescription is under the Representations of People's Act of 1951. Remember this. According to Section 8, Clause 3A, Section 8, Clause 3A, a person can be disqualified when they are convicted. They can be disqualified as a member of the parliament if they are sentenced for imprisonment for not less than 2 years, and they are barred during this period to contest election plus 6 years after that. So this is going to be a very hefty procedure. That is why Mr. Rahul Gandhi was not at all convicted, because the case was not strong enough actually. So I hope you understood how we had to go through this particular class. Make sure you're a subscriber to my Telegram channel as well. If you liked it, make sure you share it. Thank you so much.